Hey everybody, so these are my opinions on the hearing on October 5th for the Skeptic Feminist Murder Trial for Alexander Kolpakov, aka Russian Deadpool, who killed his girlfriend Heather Annabelle, aka Poison Ivy. So I've already given you the video, my previous video, where I just read straight from my notes from the 2 hours that motions hearing was, right? I had a lot of thoughts that were going through my head as I was writing, and first I'll say, if there were any questions that were just duplicates of the prosecution or the defense, you know, asking the exact same question, I might have skipped them in my notes because, well, one, they were asking questions a lot faster this time, like they had a lot to get through, and two, some of the things that came up had me thinking about the case rather than just taking notes. So, I'm pretty sure I got all of the first iterations of each question, but there were a couple questions that I just skipped taking the notes on that because the question had already been asked and answered, and they were just asking it again. So, also, when I introduced in that last video that if I had thoughts on this part that I was going to snap my fingers so you'd know that I was going to give my opinion on that particular question or bit of evidence later in this video. And that goes back to my time in the military when I had a couple sergeants that had this practice of stomping their feet whenever they read a fact from their training that was going to be on a test later. So it was in reference to a horse that would be able to do math problems, and he would clump out the number, you know, clump, is that a word? Clop. You know, he would stomp his foot, like you say, what's 2 + 2? He'd go. So they picked that up as like their inspiration to basically give a nod and a wink, you know, while they were doing training that like this will come up later. So that was my, you know, wake up snap. And I've seen instructors and professors do this at other times, or like put a little star next to what they're writing on the chalkboard and say, hey, this should be in your notes because you're going to see it later, right? So the last thing I think I want to say before I get into this is a lot of this seems to be not about whether or not Alexander did it. Okay? It seems like the defense is playing a game of, okay, we know he did it, but how many years is he going to serve for this? You know, what are the mitigating factors to this? We're going to concede that he did it, but there's other things, and it seems like the things they're going at are mistreatment by police, evidence tampering, evidence mishandling, evidence destruction, and I'm going to say inappropriate investigative tactics as far as the timing as when they were speaking to Alexander, and I'll get into that. But it doesn't seem like they're trying to exonerate him in full. You know, like, it looks like they just want murder off the table and they want it changed to manslaughter. And maybe this coming Friday, when they do the motion for a new trial, which even that title for that motions hearing seems off to me, but maybe they will change the charges and maybe a plea deal can be hammered out just on that. If it's understood by the prosecutor, by the DA, that this was just a tragedy and manslaughter, and it was not murder, then maybe Alexander would be okay with that plea. And just taking manslaughter years. Anyways, there was nothing that really stood out to me about who was in the room for this hearing, except for that the expert witness, they called him expert witness when they were introducing who was sitting behind the defense, the guy that was sitting in the first row in front of me. But these proceedings have been sequestered, in that nobody who's going to testify is allowed to hear the testimony of other people. Which also plays into the way that some of the officers' testimony is now contradicting itself. Like, they're contradicting each other, rather. Because, they're not allowed to compare notes. And they're not supposed to talk to each other outside of this. And I'd say the contradictions that have come up in this hearings process between what the officers have said about what happened when they took Alexander into custody, I'd say that that's kind of proof that either they're really inept at comparing notes, or they didn't, as they shouldn't, because the hearings are sequestered and everyone who's a witness should not be talking to other witnesses or comparing notes or trying to find out what the other people said. So, let's see. When Deputy Simon was sworn in, originally I didn't think anything was going to come of this. I thought she was just going to reiterate what the other officers had said. The first contradiction was the distance that Deputy Simon was away from Alexander when she had her AR-15 and was keeping him while the other two officers cleared the apartment. The other officers indicated a greater distance, and she said herself that she was 3 to 4 feet away from him. What does this matter? Don't know. Really, in the grand scheme of things, is the defense trying to go for, they mistreated him by pointing the gun directly at him from 3 to 4 feet away when he was the shooter? I don't know how you guys feel about this, but in my opinion, when somebody has been identified as a suspect in a shooting that quickly, I'm okay with guns being pointed directly at them when they're told to, stay right there. They see a gun right next to a dead body, and this guy's covered in blood, and he's at the scene. I'm like, no, he's speaking incoherently. Oh yeah, keep your gun trained on him for your own safety. So the fact that she later said that her gun was slung and she wasn't pointing it directly at him, I'm like, okay, well, that's you. If you think that you can draw quickly enough if he charges at you, fine. Don't stand 3 to 4 feet away from him with your gun slung, not pointed at him, because that gives him the opportunity to get up and grab your gun. Think about your own safety, woman. Urgh. Anyways, the other officers said that she was standing at a greater distance and they couldn't tell whether her gun was directly trained on him. That was a little bit better. But that wasn't her recollection. Another part of her testimony that contradicted the other officers, prosecution asked, was Kolpakov put in restraints before he was put in the patrol vehicle? She said, not that I was aware of. Whereas other officers said that yes, he was put in leg restraints, basically handcuffs for your legs that are specialized for that. Also, let's see, we went over her AR-15 was slung, which, that's the answer that they're going to give. Back up a second, back up. A lot of what I'm saying here is just proof that the Mesa County Sheriff's Department needs to pass out a couple of fucking body cams because they don't recall things perfectly. And these body cams, if just one of these officers had one and turned it on, none of this would fucking matter. They would just turn in the fucking video. I love video, right? I'm a video blogger here on YouTube. I love video. Because it remembers better. Okay. Alright. So, Deputy Simon was asked, the best course of action was to get Alexander into the patrol car, and she said, yes. Well, as I go on here, this will contradict some of what the other officers said. So the defense asked Deputy Simon, did you hear Alexander say, I had to put my sweet Heather down? Right? She said no. Now, she was 3 to 4 feet away from him for the longest time, and then when he was being helped into the patrol car, because she had the weapon that would be, you know, a little bit awkward to help out with that, she had to stand back a little bit. But she was never far away from him enough that she wouldn't be able to hear him say, I had to put my sweet Heather down. And she said she didn't hear it. And that contradicts what the other officers say, especially Lieutenant Holdren, who was the next person called to the stand. One thing that the officers recall differently is who showed up when. Bailey said that him and Holdren showed up, and then Deputy Simon showed up. She went back to her car, got a rifle, and then joined them, and they all three kind of went in together, right? Holdren just says that they all three arrived at the same time. Which, it's a really kind of moot point when you think it, in the grand scheme of this stuff, they're planning to concede that he did it. It's just a matter of the circumstances. Why does it matter exactly what order the cops got there, or what they think the order was based on their feelings? Because both statements could be true in that the officers all arriving at the same time, in Lieutenant Holdren's opinion, could just be like they all arrived in the same minute or the same 30 seconds, you know, the same time, you know. Things were happening quick, I take it. Another part of the statement of the deputies that is in contradiction is Lieutenant Holdren says that he asked for handcuffs on Alexander right away after he came out of the bushes and got down on the ground. And then he proceeded on to the apartment where he found Heather's body in the threshold, you know, on the doorstep, blood on the threshold, and the gun. Which, that was the point that other deputies said, that after he saw the body on the doorstep, that he called back to them and said, cuff him. Right? Maybe he said it twice and they didn't hear him the first time. Maybe they're just remembering things slightly different. I wish there were body cams. Does it really matter in the grand scheme of things? Hopefully not. So Lieutenant Holdren was asked, what kind of questions did you ask Alexander at that point? And he said, I asked him, who did this to you? And he said, my name is Alexander. Lieutenant Holdren is the only one who heard that statement, right? And that statement, while it isn't a correct grammatically response to his question, it is possibly something that you could consider a statement of guilt. He asked, who did this to you? And he said, my name is Alexander. Referring to himself, like, I did this, right? So this is a statement of guilt that Lieutenant Holdren remembers that none of the other officers remember. He also asked, who did this? And then he said, I had to put my sweet Heather down. I'm really thinking that statement of guilt as well, if Lieutenant Holdren was the one who told media that was what he said, and then the media wrote it, and then the other officers looked at that news story, the officers that did say that was something that was uttered could have been influenced by Lieutenant Holdren saying that he heard it. And at this point, I'm thinking it would be a very a viable option for the defense to go for Lieutenant Holdren's statements might be inaccurate and throw all that out. Does it really matter? If the other parts of this case played out to the point where Alexander was considered so far under the influence that he could not control his actions, and that this was just manslaughter because Heather was the one who gave him the drugs, and maybe he was unaware that he was getting those drugs. He was uttering, she poisoned me, right? If all that is the way the case goes, it doesn't matter about his statement of guilt. He's conceding his statement of guilt. He's conceding his guilt. He's not conceding the statement. But whether or not he said it, it's moot. If the case goes towards being restructured as just a manslaughter case. Now, if it stays a murder case, then yeah, every statement of guilt needs to be challenged as much as possible. And so, yeah, the fact that the officers disagree with what was said, internally with all their recollections, especially with something as important as a statement of guilt, and they're, experienced officers of the law, yeah, I think that's very important. If it stays a murder case. The next part of the testimony of Lieutenant Holdren that contradicts the other statements of Bailey and Simon is Kolpakov resisted getting into the patrol car, so he had to be transported to the hospital. He was then asked, was Kolpakov put into a patrol car, and he said no. Now, the other officers, especially Bailey, indicated that he was put in the back of a patrol car, and Lieutenant Holdren was asking him questions. Lieutenant Holdren remembers that he was never in the back of the patrol car at all. They tried to put him in one. He resisted. They took him down a little bit, and then he was put in the back of an ambulance. And as far as was he put into a patrol car, Between the 3 officers that were initially on the scene, it's 2-1, yes, he was. Add O'Neill, that's 3-1, yes, he was. Put in the back of a patrol car. And the officer in charge of it all says, no, he wasn't. Same officer who heard, I had to put my sweet Heather down. Lieutenant Holdren, one out of the 3 officers who approached, quote-unquote, at the same time, was the only one who reported that Alexander was first standing around or over the body of Heather before he went to the bushes. Now this, if we're looking at Lieutenant Holdren as somebody who is trying to help make the case by adding a little flair to his statements, he's already made reports of statement of guilt that the other officers didn't seem to hear. And now he's trying to place Alexander directly over the murder victim, because the placement of him in relation to the scene where the gun and the dead body are important to the case. So out of the 3 officers that approach, one of them sees that he's in the doorway in that area and then runs to the bushes. The other 2 were approaching and then they saw a man behind the bushes. It's a matter of 15, 20 feet, you know, not that far. And maybe in the dark, only Lieutenant Holdren's eyes were good enough to see a little bit of a streak towards the bushes. Mind you, this would be like twilight-ish, past twilight, because the dispatch called it at 9:15 p.m. Right, so maybe there's a little bit of a glow in the sky, not a lot of light, no street light on that street, right? So what they're seeing is they're having a hard time seeing, right? It's dark. If it mattered, and they were defending Alexander for like 1st or 2nd degree murder, and not like manslaughter, I would say, having already proven that Lieutenant Holdren seems to have a bias in the flair that he recollects things, then maybe they would say, well, he's also, you know, after he's like the one who heard these statements, quote unquote, and then he's you know, he's the one who's trying to place him closer to the body. Maybe Lieutenant Holdren is somebody who will tamper with evidence just to help, because maybe he's a little overzealous. Maybe that's how he became the lieutenant of patrol. You know, he's a little bit more gung-ho, and that might help Alexander's case if it was just like a murder case. Anyways, so when defense was able to give Lieutenant Holdren his cross-examination, the last question they asked him was Alexander put in the back of a patrol car? And he said, no, he resisted and we restrained him. And that's when the judge, taking his own notes with his own computer, asked, could you clarify the order of questions that you asked him? You know, and it was the same as what I read in the previous video. But the judge even was like, and was typing away on his own computer. Like, this seems a little bit off. Next, the next point where I had some big thoughts about this had to do with when Alexander was taken to St. Mary's Hospital. The first investigator to get there was investigator Danny Norris. Now, the important part that I picked up, I think, back up. It's important for you guys to know that for a year or two, I was a security guard in hospital emergency rooms. There's videos on my channel here talking about that. And also now, I am an addictions counselor where I deal with people who have been on a wide variety of drugs. And so I've been in settings for my job like this for years now, right? So some of what I'm telling you is just based on my professional experience. When investigator Danny Norris said that when he got to the emergency department, Klopakov was passed out, quote unquote, and then he waited until he was stirring. I'm not sure that stirring is enough of a prompt to tell you that, oh, now he's awake. That's something that you do for somebody like out of courtesy because you know that they need their sleep because they have to go to work, so you're not going to bug them with like, oh hey, did you pay the cable bill? You know? You're going to wait until you think that maybe they're already awake on their own because it doesn't really fucking matter in the moment because they need to sleep to get to work. This was not like a courtesy thing, you know, where, oh, well, he needs his sleep, so I'll wait till it looks like he's already awake. I'm not going to wake him. No, this is a fucking murder investigation, right? You either need to talk to him or not, right? If he's rousable, you fucking say, hey, do you mind if I ask you some fucking questions? How do you feel? You know, do you feel up to this? You don't sit there and watch him passed out and then wait till he's stirring to try. No, you fucking make an attempt. Better yet, ask the fucking charge nurse of the emergency department to do it for you. You know, and then she can give you a medical opinion as to whether or not he can answer some fucking questions. Right? Have a behavioral tech that's right there. Have the security guard that's right there. You know, wait till he's stirring. It's just a convenient statement that the investigator made. I just sat there and watched him, Sleeping Beauty, and then when I saw him stir just a little bit, I was like, okay, well, his sleep is already disturbed. I'll go try to talk to him. So I did have thoughts that it is proof that he was impaired when the first time he was read his Miranda rights by Officer Norris, he said he didn't understand. And then the second time, he said, okay, yeah, I think I understand. If you can't get it the first time, especially, you know, somebody who, my goodness, he's a former soldier, he's a veteran, right? And also, he used to teach self-defense classes. Like, he's got the mentality that he knows in his normal uninebriated self-life, he knows what Miranda rights are. I'm pretty sure, given the subject matter on his channel, he has gone over civil rights. Absolutely sure. So the fact that he didn't quite get it the first time, something's up, right? And if you're trying to make the case that yes, he was not in his right state of mind, not really being able to say that, yeah, I understand my right to remain silent, he's fucking troubled in the head at that moment. There's something wrong. There's something going on. Possibly intoxicated, right? So, he said that he needed more rest. He felt extremely drowsy, right? He said that to both investigators. Could be that he was on a sedative from the process of transporting him from the murder scene where he was extremely agitated and aggressive towards officers and medical staff. Could be that they did a pretty much standard dose of Versed, right, in the field. Every EMT would be able to have access to that on their truck, standard. You guys might not know this, but I'm going to say 95% certainty he was hit with Versed. Right? And it was probably in the field. And if he was still aggressive when he got to the emergency room, they would have administered Versed there. Right? 5% chance that he made it to the emergency room, strapped to that gurney, and he was non-compliant and aggressive and everything, and they gave him a high dose of Ativan, right? Now, both of these drugs, Versed and Ativan, they're benzodiazepines, and they have certain effects on the human body. For one, Versed especially is for treating people who are agitated in order to put them in a passive state and pretty much make them go to sleep. It's a sedative. Both of them in therapeutic doses, they are sedatives, right? Both of them are given to causing side effects such as anterograde amnesia. So at the moment that they are administered, there's plenty of scientific evidence for this. At the moment that they are administered, the person who has been hit with Versed will have a problem forming memories until the effects wear off, right? Versed and Ativan are often used in surgery to prevent people from making horribly painful memories about the surgery. They are not something that you would want to interrogate somebody on, because the entire interrogation would be something that pretty much would be thrown out of court, because the person is being chemically induced into a state where they can't remember the last question you asked them, right? And so he said he needed more rest, and 4 frickin' times he asked the investigator, how did I get here? Right? How did I get here? That's because he could not remember the last time he asked what the answer was. That's how these anterograde amnesia spells work. When you're hit with that much Versed that it's a sedative, or that much Ativan that it's a sedative. And I'm pretty freaking sure it was Versed, and it was probably administered in the field in order to help the transportation process of Alexander while he was in the ambulance. Side note, the officer said that hands bagged is a common procedure, and he said yes, that is a common procedure. Not really. Normally, you don't find the person who's the shooter in the emergency room right after a shooting. Like, at this point, I'm wondering who bagged the hands, right? Was it officers? Officers bagging the hands, like, and then having them restrained in, like, a jail setting, I wouldn't be familiar with at all. Like, whether or not that was a common procedure. But in the emergency room, Hands bagged? No. No, not common in any of the jurisdictions that I have worked in. But I would agree that it was a good thing, and good if one of the officers recognized that need and bagged his hands and then made sure that he preserved the evidence and that officer documented it. That was a good thing as long as the documentation of him doing that happened. But as far as it being a common practice, 2 years in emergency departments, watching all of the aggressive clients that came in all of the emergency rooms in the Denver metro area, and I've never seen it. Just saying. Maybe I needed another year or two of experience to see that particular procedure, but even then, it wouldn't be common. Already went over that. When Investigator Berg got on the stand after Investigator Norris, he was asked, "What did you observe about Alexander?" And he said, "He was calm, rational, tired, and sober." Right? This was 4:30 in the morning after he had been hit with Versed, probably around 9:30 at night. So 4:30 in the morning, after he was hit with enough Versed to sedate him and make him compliant. 4:30 in the morning, Investigator Berg thinks that he looks sober. Even though he's saying, "I'm extremely drowsy right now." Even though he's asking the same questions over and over again, like he didn't hear the first time, Investigator Berg thinks he looks sober. You can probably look up for yourself the biological half-life of Versed and Ativan, and they last a little bit longer than a field prick from 9:30 till 4:30 in the morning. They're still going to be under the influence of that drug. They're still going to be under the spell of anterograde amnesia. There might be a little bit of retrograde too. You know, giving someone some benzos of that strength would affect the memory formation of things that they had just experienced right prior to the injection too, right? Not as much evidence about that because, you know, doing clinical trials about amnesia to people is kind of, you know, a problem for ethics, but that's above and beyond what we're talking about. I'm saying he was still under the influence of those drugs. Whether or not he had been hit by those drugs would be something that you would look up in their chart prior to interrogating them. You could just ask the nurse, the charge nurse of the emergency department, "Hey, has he been given any medication?" Right? It being exigent circumstances like a murder investigation, it's something that would not be something that the nurse would say, "Oh, he's got confidentiality rights and HIPAA and whatnot." No, they're going to say, "Yeah, we had to sedate him." They'd give him an answer of like, "Yeah, he's not really with it, but you can go ask him some questions if it'll do you any good anyway, you know, but he's not really with it." So, Investigator Berg, having a person who has been hit with Versed in the field or some sort of sedative, then puts a form in front of him and says, initial by all of these things, in order to say that you are sober and you understand all of these rights that you have, and then sign here saying that you want to talk to the police to explain your case, right? Remember how I said I wish they all had body cams? You know what else would be great for investigators to have? An audio recorder, maybe, just to place in the emergency room if they are taking statements from a suspect. Or, better yet, a video camera. Set it up on a table. Like, you know why he didn't have that conveniently turned on? Which they should have it if they're investigators. They should have this as, like, standard equipment in their precinct. You know why he did not bring that into the room? Because he's using this form to say, okay, well, he understood his rights. He shouldn't have signed or initialed if he didn't. Right? And you don't get to see what he looked like when he was trying to sign. You don't get to see what he looked like when he was initialing. You know what would be really great, though? If they brought in a handwriting expert and they compared Alexander's signatures on, say, his own checks from his the scanned checks in his bank account versus the signature on that form. So I tell you what, you're hit with that much versed, your signature is going to look a bit different. Here I am making the defense's case for them. Anyways, defense on cross-examination asked Investigator Berg, was he given a sedative? And he's like, I'm not sure. And that's definitely something that he should have known before going in there. But it's convenient that he says, I'm not sure. When the signs of him being sedated are right there. He's saying he's extremely drowsy, probably nodding off, and they're not telling the court, was he nodding off? Was he falling asleep in the middle of what you're saying? Like, no, he said that he was extremely drowsy. That's the way he said it was basically like he was treating Alexander like he was an uncooperative witness. Well, that's what he said, but I didn't believe it, right? Like, defense asked, did he appear groggy? And his response was, he said he was extremely drowsy. So the investigator's answer to the question was what he said, not what he appeared like. The question was, what did he look like? And the investigator offered what he said. You guys picking up what I'm putting down here? That wasn't what the defense asked. He's avoiding answering the question because he knows that he got a person to sign something while they were not able to consent for things because they were under the influence of drugs. Obviously. Right? You know what would be great for their case? For the defense's case? Did the hospital ask him to sign a consent form for treatment? Right? You know why they wouldn't have at that time? Because he was unable to consent because he was fucked up. You don't give someone a legal document and have them consent to something when you know they are intoxicated because you gave them the drugs yourself, or because they came in with the signs and symptoms of intoxication. Intoxicated people are unable to consent for a lot of things in this country, such as sex or legal contracts. Okay, so the final thing that I think I had some opinions on was the evidence. As far as the investigators. First of all, the investigator not being able to pronounce psilocybin after, this is a year and a half later into the case he's had that he could have been preparing to be able to say that one fucking word. He couldn't pronounce it. Exiled, my good friend, she left in the comments of my last video that she didn't understand which blood vials had been tested and whatnot. And I know from my notes and from the questions asked, it's a bit confusing because it was confusing to me. My understanding from the questions that were asked is that a grand total of 6 vials of blood were taken. 3 when Alexander initially got to the hospital, and 3 many hours later. Right? And they read the time that the second draw was, and that was 2:42 a.m. Okay, that was the second draw. That second draw, from one of the tests that was conducted, from the second draw, they did confirm that there was psilocybin in the blood. One of those vials was sent to either CBI or the police investigators, and it came up with no drugs detected whatsoever. Right? So, there were 2 separate draws, hours apart. One of the vials from one of the draws was sent to a department. I don't know which one from the questions that were asked that I could not understand, but one of them saw nothing at all in the tox screen. And one of them did confirm that there was psilocybin. Now, this was all for a motions hearing about the suppression of evidence based on destruction of evidence from the defense. Which tells me that all of these 6 vials are apparently not available for the defense to retest them. We're only going on what the police investigators were looking for and what they were willing to pay for to look for. So, in none of the reports about this blood was there any mention of whether or not they tested for a substance like PCP, which Alexander had said that the substance that the mushrooms might have been tainted with might have been PCP. Let me tell you what I noticed while sitting in that room. Try to follow along here. Alexander's groggy, right? He was already acting messed up while he was at his apartment. He was acting erratically for hours. That has been established, right? He's taken into custody after the killing happened, right? He's probably hit with Versed or maybe Ativan, probably Versed, right? Hours later, like first one is like 1 hour later, and then the other one's a couple hours later after that. Hours later, they take blood from him. They do a tox screen for possible drugs that were in his system. And all but one of them find psilocybin. Which matches the fact that there were mushrooms at the apartment. You know what's missing from this? The tox screen is not showing simple benzodiazepines. And if it's not testing for benzos, what else is it not testing for? That is a simple catch, right? Why would it not be testing for benzos? Because the investigators would not want it to be known to the jury of a possible murder trial that they were interrogating Alexander while he was intoxicated with benzos. So they would not ask for that. They would ask for specific tests for just psilocybin, because they don't want you to know that he was on other drugs that would have affected his judgment while he was being questioned. So I've been in residential treatment facilities where I've sent out urine samples to get tested by outside labs like Redwood Laboratories in California, where I can FedEx a urine or blood sample, and within that week I can have the results of every sort of kind of drug that there is. And if it's opiates, they will do another test even further than that and tell you whether it was methadone, Suboxone, heroin. You know, they will break it down, like specifically which opiates were there. You know, was it OxyContin? They can tell you, right? For benzos, they can tell you if it was Ativan. Like, just with the standard test, you don't have to pay anymore. If they detect a benzo, they're going to immediately test for Ativan, or was it something different, you know. Those tests are not that expensive, right? That simple test. And you know what happens if one of my clients has a urine sample that does have a drug in it, if they come up positive for something? They immediately set the rest of the urine bottle aside in a different fridge. So just in case that client says, I need it retested because I need a second opinion, they're able to take that bottle out and go, okay, we're going to test a little bit more of it. Right? The difference for destruction times that I'm used to from an outside lab. If the sample is clean, within 90 days they're going to destroy the sample. It's no longer needed. If it is contaminated with an adulterating substance, if it is positive for any drugs, they're going to at least hold on to it for that 90 days, and then longer, depending on which service you use. If it was Redwood Laboratories, I would expect an entire year. They've got a fridge for it. That's what they get paid to do, right? So if CBI sent samples to an outside lab, the standard practices of that outside lab need to be discussed, because if Alexander was not given access to his own samples for testing, they were hiding those samples by not telling the defense, oh, those samples still exist in a fridge somewhere, because standard operating procedure for that outside lab is to hold on to it for a certain amount of time. If they waited until such time that that sample would have been destroyed in order to tell the defense that it existed, there's the destruction of evidence case right there. I thought it was particularly disturbing that not only could the investigator not pronounce psilocybin, but he also, up to this point, had never seen a coroner's report from Heather sent to the police department. Holy shit. It's been a year and a half that this case has been going on, and he still hasn't seen that little bit of evidence, and he knew he was going to be in court today. Holy shit. Goddamn. Brush up on your notes. It's disturbing and a little convenient, right? But based on that, the defense was able to just add that defense exhibit. I mean, the prosecution was objecting, but the judge allowed it. So that evidence is in. The blood tests that were done as evidence that is in, and the fact that they don't show Versed on them when it's probably very easy to prove. The report from the ambulance would have it, and that report gets handed to the emergency department, and then it gets scanned into someone's medical record, which Alexander would have very easy access to. All he has to do is ask, or his lawyer can just go down there to the hospital and say, hey, give me the reports on what drugs he was given while he was here and in the field. And they'll have it. So they can tell the court exactly how much benzos he was pumped up with. Like, to a measurement, right, of how much benzos was in his system. Be able to do calculations of how long it would be in his system based on that. And then show, hey, and all of the tests that the police did conveniently don't have benzos on them. What the fuck? So, the timing on what is CBI item 1, which is actually the second blood draw, it was taken from him roughly 5 hours after police were on the scene, and that was at 2:42 a.m. That is long enough for the metabolites of whatever he was sedated with to be present in his blood, in his urine, and those metabolites do not leave your system in even a matter of days. Days later, you can still test for that shit. I know, I've lost clients out of my programs because they took benzos and then thought they'd be okay, and then a couple days later I hit them with a random piss test and, had to kick them out of my program. I know how long those fucking benzos stay in your system. Long enough to be detected, right? So we already talked about that. Okay, last thing I'll go over is the testimony from Mr. Anthony Martinez, who was the neighbor of Heather and Alexander at the time. And he was asked, were you close friends with them? No. He got home around 5:30, right? And that's when the scene happened where Alexander had left his own apartment and went to Mr. Martinez's apartment and was up the stairwell screaming to somebody on FaceTime. I'm assuming it was Laura Athena, because from other statements from other people outside of these proceedings, that's something that has been said. And pretty much all that I'm learning in this whole process of all these hearings is basically everything Laura Athena has said is true. That's what like. We heard what she said. A lot of people on the internet went over this like, oh God, that's just so convenient, or oh yeah, he wasn't able to help himself, he had to kill her. Like he was fucked up. That's so convenient of a defense. Nope, it's all fucking true. This is a fucking tragedy. This is the way it's playing out in these hearings. To me, is that we shouldn't be hating on him as much as he has gotten hate on the internet, because this does look more like a tragedy, just like Laura Athena was explaining. It's important to note that Alexander had no clothes on when he went to the neighbor's house, and he had never been there before, and he was so out of his mind that he did that, right? That's proof of him being intoxicated. And the fact that the defense asked him those specific questions, did he have any clothes on? Had he ever been there before? Were you guys close friends? Did he have, like, regular access to? None of that. He had never been there before. That is really, really freaking strange to go into somebody else's house like that. Naked. naked, and be screaming on the phone at someone, she's trying to kill me. Very, very strange. So, of course, the hearsay that is now allowed as far as what Mr. Martinez heard Heather saying, and then him saying that she seemed to be the one in control versus Alexander, who was out of his gourd at the time. I think that was very important to the case. But also, really important is the timeline. Because people will say that psilocybin takes an hour or two to set in. You know, you don't just ingest it and then, like, kill your girlfriend because you see octopus tentacles sprouting out of her. Not going to happen. You ingest it, and then the onset of the hallucinations happens, you know, for a period of hours. You know, it doesn't happen right away. It gets worse and worse and worse. Well, or better, you know, depending on your perspective. But the fact that there were hours of this going on, I think helps his case. The fact that he was doing things prior to killing his girlfriend that proved that he was out of his fucking mind helps his case. Anyways, I guess lastly, I'm going to go to the motion for a new trial, which happens on the, let's see, I'll bring up my calendar, happens on the 12th, right? They set another hearing on the 17th, which will have a CBI non-expert, Jamie Lidwood, who did some of the tests, and then some lady named Sarah, who's also an expert in the field of testing. And they're going to have all that on the 17th, and I will not be able to go see that. The reason why is I need advance notice in order to miss time from work. And at this point, I've missed a lot of time from my job, none of which was short notice. The hearings I've missed were because they were short notice. They just popped up. And this one I'll have to miss. And then the pretrial readiness hearing, which will only be for 1 hour, I'm also going to miss that one because it happens in the middle of some work responsibilities that I have to do. So those two things I'm not going to be at. We're coming up on the dates that the trial was set for. I did apply for the first 2 weeks of the trial to have off from work. I cannot take longer than that. So if his trial actually went the full 3 weeks, then I would see the first 2 weeks and then not be able to see the outcome as it happened, you know. I would love to be able to see what the jury says, and for his sake, at this point, I'd love for them to make this new trial hearing and change the charges, and then immediately come up with a plea deal. You know, that is acceptable to him. That's I think enough justice would be served. I don't think we need to pull out Heather's mom and dad for another 2 weeks worth of sitting in those uncomfortable benches. You know, it's just, I think there's enough evidence to make this happen. You know, we don't need, and I don't know why the prosecution wouldn't do it except for the family's wishes, because that often plays a big part in what a prosecutor will do. And after every one of these hearings, the prosecution leaves and goes into this little side room off the hallway, and the mom and dad and sometimes other family members go into that room as well. I'm not allowed in that room, right? But they're talking over what the strategy of the case is, right? And so that's why the mom and dad can't be witnesses, because they've witnessed all of the other witnesses in the hearing, and this is a sequestered thing. But also, they're in on what the prosecution is doing. Their input is important because justice being done does take into account the family members that are left behind. You know, so if there is no plea deal offered at this point, that happens, that we can put all of this to rest on the 12th. It's because the family members want more of a sentence than what manslaughter would give. And my feelings on this right now are that's not really deserved, you know? Yeah. If anyone wants to help me out with the gas money that I've been spending to bring you these reports, you can become a Patreon donor if you don't have enough money for like a big lump sum of money to give me. I can afford all this. I'm just saying, if you've appreciated this and you want to help out, that's fine. I can't afford doing what I'm doing. As far as taking off the time from my work to go see this trial, I can even afford that. I wouldn't want to do it alone, but I can do it alone. Yeah. Patreon link is always down there. I thought about starting like a GoFundMe for like my hotel room for going for like 2 weeks to Grand Junction, you know. I think it might run me with long-term reservations at the place I would go, probably $200 each week, and then, you know, it cost me about $80 a gas there and back. So that's about how much this is costing me. So keep that in mind when you're thinking, like, did you appreciate what I'm saying here? Enough to fund some of it. And I would actually rather to not make it an Indiegogo at all, and just have, like, if you like this stuff, just become a Patreon patron and show me a little love over time. So yeah, that's like one of the only times I've ever done like a Patreon plug. I'm like, yeah, and really, I'm only doing it because I know that in my family, between me and Misty, I don't like that my hobby is taking up this much resources from our family pot of gold. You know what I'm saying? You know, I'd like for it to at least put a little bit back, because I'm feeling a little guilty for following my my passion here. You know, a little bit more than my other YouTube videos have cost me out of my life. So take care, everybody. Next recap should be for the October 12th hearing and should be up by October 13th. Laters.